Other two arguments, counsel will be given 2 minutes of uninterrupted time to present the key points of the case. In all cases, counsel may assume that the court is familiar with the record and need only reference it if doing so highlights an important issue. Also, appellants have had the opportunity to reserve rebuttal time in advance. If you elected to reserve rebuttal time, it will be deducted from the total argument time allotted during the main argument. If the opening argument does not use the full time, any remaining minutes will be added to your reserved rebuttal time. And counsel, as always, are not required to use all their time, as concise and focused arguments are often more effective. The courtroom clocks are located on the clerk's desk to the left and the right of the podium. And again, a red light and a bell signal that your time has expired and you should conclude your remarks. And with that, Madam Clerk, we call the first case.
Yes, Your Honor. S25A0446, Bailey et al. Versus McIntosh County et al. S25A0447, Webster versus McIntosh County, and S25A0448, McIntosh County versus Webster. Philip Thompson and Kelly Moore for appellants, Ken Gerard for appellant.
May it please the court. Philip Thompson on behalf of intervener appellants Barbara Bailey, Christopher Bailey, who are in the audience today, as well as Stanley Walker, who are all residents of the Hog Hammock community, many more of whom are in the audience today as well, and who are also three of the more than 2,300 petitioners who exercised and now seek to protect their constitutional right to a referendum repealing McIntosh County's amended zoning ordinance pertaining to the Hog Hammock community. The purpose of this petition is to protect and preserve the Hog Hammock community, one of the last Gullah Geechee communities in the United States and a cultural and historical treasure, both for the state but as for the country as well as a whole. As the court's aware, these appeals address primarily two issues emanating or remaining from the Camden County case. One, the standing of counties to interfere in the referendum process, and two, the availability of that process as applied to zoning ordinances. Respectfully, the resolution of these issues under Georgia law is clear. The county has no standing to interfere with the referendum process because it has no legal right at issue in this case. And two, the referendum power applies to zoning ordinances because all potentially relevant legislative power for counties to pass ordinances, resolutions, and regulations emanates from the Home Rule section of the Constitution.
Mr. Thompson, can we start with that second part? If I understand the question correctly, the nub of it is whether this zoning ordinance is an ordinance, resolution, or regulation relating to the property affairs and local government of the governing authority of each county, of this county.
That's correct.
Right? I mean, I understand your argument to be that the zoning power is sort of encompassed within that legislative power. There are a couple of issues with that reading, though. One is that it seems to make paragraph 4, which grants the county the ability to exercise the zoning power, superfluous. And two, if that's true, if it's sort of covered under the first provision, it seems like it puts into conflict what the General Assembly can do with respect to ordinances under 1 versus under 4 in terms of preemption. Can you address those sort of potential issues with your reading?
I think so, Justice Pitts. And so with respect first to the zoning provision being superfluous, the way we contend the Constitution is to be read is that Home Rule paragraph 1 is the conveyance of legislative power by which counties can pass ordinances, as Your Honor mentioned, respecting to their affairs, their property, and local government. And the remaining provisions of the Home Rule section define what constitutes local government or the affairs of the local government. So in reading, I think in reading some of the notes from the committees for amending the Constitution, this comes up a little bit. Why do we enumerate these specific powers? In addition to the Home Rule provision, there's some talk, and I know this certainly isn't dispositive of the original public meaning of this section, But there is some talk in those committees that we need to specifically enumerate these additional powers because because historically these powers were specifically enumerated, and they didn't want the home rule provision's grant of legislative power to be unnecessarily curtailed.
What do you make of the language in paragraph 1, sub A, that limits the grant of legislative power, where it says the governing authority of each county shall have legislative power to adopt ordinances relating to its property affairs and local government? Is that limiting the grant of power just to things, the county's property, the county's own affairs and their internal government?
I think I would say so, Your Honor, but the local government.
But if that's true, then wouldn't you need the separate provision about zoning, which would cover the property other than the county's own property? Or do you read the county's property to mean all of the property in the county?
I would read the county's property to mean specifically the property in which the county has rights as real property, or real or personal property, as if the county were a person. That these are the goods or the real property.
Property owned by the county as an entity, or property merely contained within the geographic limits of the county?
Property owned by the county as an entity, and then the
So that's going to be a problem for you then, because if you need to fit zoning under things relating to its property, its affairs, or its local government, which one of those is zoning fit under?
Local government or affairs, not the property piece of it.
Okay. It does seem to me if you read that narrowly, such that the property is only property owned by the county as a legal entity, I'm not sure what to make of the local government phrase at the end. The county's local government? I mean, the county is the government. There seem to be ambiguities that point in both directions, such that neither a broad nor a narrow reading is without problems.
So the interpretation we propose and that we think is supported by the structure of the Constitution, the history of the Constitution, the development of the grant of legislative power to counties, is that the remainder of the home rule provision clarifies the ambiguity with respect to what local government means in that provision.
By the remainder of the home rule provision, you mean the other paragraphs throughout section 2?
Yes, Your Honor.
So those are just clarifying the power that has already been conferred by subparagraph A in paragraph 1?
Not clarifying so much as granting additional power, putting these additional subjects within the local government.
Well, but there's a really important distinction there. If it's just clarifying, or I think maybe belt and suspenders, sort of showing exactly what is meant by the county's property affairs and local government, then you can get to your argument that zoning is contained within sub A, and so the referendum applies. If it's granting additional powers, I'm not sure how you shoehorn the grant of those additional powers to where they can be addressed through a petition process.
Given that dichotomy, Justice Pinson, we would absolutely contend it's more of a clarification. But even under an addition of power, we would look to the history of our previous constitutions to show that the explicit grant of legislative power is important. All of our previous constitutions, all of them with respect to the zoning power, have contained or been accompanied with an explicit grant of legislative power.
But I don't get that argument, because paragraph 4 is an explicit grant of legislative power. It says that the governing authority of each county may adopt plans and may exercise the power of zoning. The power of zoning is a subset of the legislative power. So I don't understand that you need a separate grant of legislative power. These may be belt and suspenders grants of the same power, which I think is your strongest argument, but I don't see how that's just not a grant of power.
I think the the zoning power is not just does not just suggest or include legislative actions. It also, looking at the Zoning Procedures Act, includes administrative actions, non-legislative actions. zoning decisions as opposed to zoning legislation. However, it is the zoning procedures.
So is it all
delineate.
important, counsel, in paragraph 4 that there's also a grant to municipalities? Because you have constitutional home rule for counties. Then you have basically a recognition that the General Assembly can do statutory home rule, which they've done, but that's a separate provision. But then in paragraph 4, municipalities also get the power to zone. Is it relevant to sort of trying to say this is a separate power that's being conferred on local government, is the power to do the thing that can't be sort of encroached upon by the General Assembly? But that doesn't, I mean, it sort of would be backwards to say we're giving you a power that you can't use home rule for. With municipalities, you would say this is something that whatever the General Assembly does in the home rule space, the Constitution says you have the zoning power. I mean, does it follow to me that if the Constitution says you have the zoning power, counties, and in Constitution you also have the home rule power, it can't be a weaker power than you get under home rule?
I certainly would not categorize it as a weaker power. I think the argument with respect to cities, municipalities, is unfortunately that seems to be a little bit of an artifact of the strange history of the development of home rule in Georgia's tradition. For some reason, not entirely clear to me, the decision was made to keep municipal home rule statutory versus county home rule constitutional. I think because just the various different preferences between the two interest groups.
Well, and generally speaking, anyone who uses the phrase home rule generally isn't entirely sure what they mean by that. I think that's part of what's
Counsel
going
at
on
the podium included.
Counsel, let me ask you this. I mean, just looking at the context of the home rule provision, one of the other paragraphs, paragraph 5, deals with eminent domain, right? And so, but if you look under paragraph 1, it says that eminent domain power is excluded from the referendum provisions. So doesn't that suggest that the zoning power is treated the same way, that it is a clarification or additional power under subparagraph A, but it is not excluded from the referendum provisions under subparagraph C?
I think that's right, Your Honor. I know generally speaking that the referendum power appears on its face, paragraph B, has fewer restrictions, or at least purports to have fewer restrictions than the general grant of legislative power under paragraph A, where the General Assembly can modify how counties are supposed to exercise that power, whereas B1, or subparagraph B, sorry, paragraph B2, at least the only restriction expressly contained in that paragraph is that an amendment initiated by referendum cannot be inconsistent with general law, which makes sense because the county electorate doesn't have the positive power to generate new legislation. They only have the power to repeal or amend existing legislation, so it's not a new act of legislative power they're engaged in.
Mr. Thompson, can you address, I know your time is short, but I hope the Chief will indulge me. Can you address what seems to be the other ramification of your interpretation, which is if the zoning power is encompassed by paragraph 1 sub A, if that's a grant that includes the zoning power, it would seem to say that the General Assembly still has the power under that provision to broaden, limit, or otherwise regulate the exercise of zoning by the county. But under paragraph 4, it says, this authorization shall not prohibit the General Assembly from enacting general laws establishing procedures for the exercise of such power, which they have done. Do you see the conflict or tension there between this is sort of reserving a much broader power for the General Assembly. This grants that power to the county and reserves a sort of procedural power to the General Assembly. How do you harmonize those?
Yes, Justice Benson, we would actually say that supports our argument because the more general provision under paragraph A constitutes the general grant of power that would control in the absence of more controlling specific provisions. So paragraph A is the general grant, or paragraph 1, excuse me, is the general grant of legislative power that would cover just subjects generally, or powers within the county's control generally, and then the paragraphs that follow modify that or describe what's within the local government, the power of local government under the legislative power, and also sets out different guidelines in terms of what the General Assembly can do with respect to the additional.
So is your position that the General Assembly can substantively limit the zoning power, or only procedurally under paragraph 4?
No, Your Honor, only procedurally under subparagraph 4, because that subparagraph is the more specific provision.
So that it sort of overrules or supersedes the paragraph 1 sort of broader reservation of power to the General Assembly?
No, Your Honor, we would say it more helpfully explains why these why these powers might be set out in separate provisions, because this enabled the drafters of the Constitution to maybe set forth different limits or different guidelines within which the General Assembly can act on these powers of the legislature. So some of them, some of the supplemental powers, for example, the General Assembly has more power to substantively restrict, and that might be why the framers separated out the zoning power, because now, even though it's still, the general grant of legislative power is still how the county passes a zoning ordinance, the ability of the General Assembly to substantively restrict or act upon the county's zoning power is now limited by the provisions of the separate paragraph. It's not because it's conveying a separate additional implied, which we think it would have to be implied because, again, all the previous constitutions contained explicit grants of legislative power accompanying the zoning provision power. It's more that, again, these are ways to explanations or account for different abilities of the General Assembly to interact with these local powers on different levels. Thank you.
Ms. Moore?
Mr. Chief Justice, may it please the court. I'm Kelly Moore, and I represent Judge Harold Webster in this matter. He is the probate judge in McIntosh County. Judge Webster acted within his subject matter jurisdiction in granting the petition and referendum in this case. This court visited this issue in Camden County versus Sweat and ruled that subject matter jurisdiction under subsection B2 of the home rule paragraph lies within the probate court judge. And he acted in that jurisdiction in considering the petition and calling for the referendum to put the question to the voters.
Counselor, did the court accept the ordinance in the evidence? Was that actually submitted in evidence?
I believe that it was part, I don't know, Your Honor.
Okay.
I'm not
Thank
sure whether it was or not. Subsection B2 of the home rule paragraph gives voters the power to repeal or amend county-level legislative decisions in the form of ordinances, resolutions, or regulations, including zoning ordinances. Zoning ordinances are not excluded from subsection B2 of the home rule paragraph. There is nothing in the zoning paragraph or the home rule paragraph that excludes zoning ordinances, and specifically the leading language of the procedures by which local county level legislative action can be amended or repealed says, except as provided in subsection C, you can amend or repeal local legislative acts by one of these two processes, one of them being that the people have the power under subsection B2. Well, there's nothing in subsection C that lists zoning ordinances.
So what is the nature of Judge Webster's interest that is different from the other parties on the appellant side of the aisle?
Well, Judge Webster, of course, is not an advocate here for either side. He's a neutral in this case, and he was sued by the county strictly because of the relief that was being sought against him. I mean, we filed a motion to dismiss at the trial court.
Was that official capacity or individual capacity?
He was sued in his official capacity. Okay. We did file a motion to dismiss at the trial court level, raising that, number one, he's acting within his jurisdiction as this court ruled in Camden County versus Sweat, and number two, he's not a proper party for the relief being sought against him because Declaratory judgment requires for there to be parties in controversy, and he wasn't a party in controversy here. I believe that the county could have sought the same relief by bringing an action against the petitioners, the ones who are seeking to have the vote, and sought an injunction to...
Here's the other piece of the suit against the judge that I find a bit odd. Our case law makes very clear that suits against officials in their official capacity are actually suits against the government of which they're an official.
Correct.
He's a county official, right?
Yes.
So isn't a suit by the county against a county official in their official capacity essentially a suit by the county against the county?
I believe that's correct, Your Honor. I mean, I know that they are standing on equal footing. They are co-equal branches of the county government. So in effect, the county is bringing action against itself. I think that kind of goes back to some of the standing arguments that were made by the interveners, that the county doesn't have standing here either. But certainly from the probate judge's perspective, the probate judge is not the proper party to be sued here. He's acting within his subject matter jurisdiction. He's not a party in controversy. The motion to dismiss should have been granted as to Judge Webster, and the trial court was erred in not granting it.
But counsel, who is the correct party? When you have a writ of prohibition, you're seeking a writ of prohibition. I mean, it's the official who's the party, but usually isn't that brought in the individual capacity?
I see what you're saying, Judge. The writ of prohibition is to keep a court, a tribunal, from acting outside of their jurisdiction.
Well, and so, I mean, that's precisely the kind of case that you would bring against an official in their individual capacity, right? When they're acting sort of outside of their authority
Correct.
or jurisdiction, traditionally.
Correct.
And so, I mean, arguably the problem here is simply that the county sued itself instead of suing the official in the individual capacity, which would be a basis for getting rid of the suit, right?
Yes, correct.
Thank you, counsel.
Are there any more questions? Thank you.
Mr. Gerard. And if you need it, I'll give you a couple extra minutes at the end, given that I gave Mr. Thompson more time.
Thank you, Your Honor. May it please the court, my name is Ken Gerard. I'm here on behalf of McIntosh County. It's a pleasure to be in front of you today. My job, I have a couple of jobs today, but one of my jobs is to try and convince you that the power of zoning and the home rule power are absolutely different, and there's a reason that they are different. It's on purpose. It's borne out in the evolution of the Constitution. It's borne out. We had a couple of moments during my colleague's discussion with the court with respect to why there's these enumeration of powers in the Constitution with respect to counties. I want to go ahead and answer that on the front end. The reason is because Georgia is a Dillon's rule state, and you see that manifested repeatedly in your case law. A Dillon's rule state means that unless a power is expressly given to a governmental entity like a county, the inference is that the county doesn't have it. So this idea that there is some sort of a legislative omnibus umbrella that gives the counties all of its powers is inconsistent with every bit of the evolution of how counties have been given power since Georgia has been in existence. That's the reason that we have an enumerated power on eminent domain and the Supplementary Powers Clause. The Supplementary Powers Clause, just to stop real quick, because that is case in point, Article 9, Section 2, Paragraph 3, enumerated, granularly spelled out power after power after power. Why would that be in the Constitution? Literally the act of a people creating a government. Why would we talk about the fact that a county can operate a park system? And the reason is because we are a Dillon's rule state and powers have to be expressly provided or counties don't have them. That's why. And so the idea that the home rule power and the zoning power are the same power.
But counsel, let me ask you this. I mean, I don't see that as being necessarily contradictory, because I agree with you that Georgia has had I guess the Georgia legislature has tried to keep its power over the course of a couple of centuries, and it was only fairly recently that the home rule was permitted. But is it really inconsistent for the legislature to separately award zoning power to the county and then subsequently create procedures under the home rule provision to govern that power.
Right. So let me back up and say this. I do think that the powers are absolutely different. And to answer your question, it's not just the naming of the power, the home rule power versus the zoning power. Those are just names. Those are labels. It's the substance of the power that is different. The home rule power has hallmarks, has attributes. Number one, the home rule power is always subject to preemption by the General Assembly, period, hard stop. That is where the county is chiefly a political subdivision with an emphasis on the sub. Number two, the home rule power can be limited by the General Assembly, can be broadened by the General Assembly, and the home rule power, it says it right there in the first paragraph, you can't exercise your home rule power if it is, quote, inconsistent with any local act creating you. And of course, a local act is simply a manifestation of General Assembly power applicable to a single jurisdiction. So 4 different hallmarks where the General Assembly makes clear that when it comes to home rule, we're in charge. Well,
Mr.
the
Jordan,
people have said that.
Mr.
But
Jordan,
not zoning. Yes.
Can we talk about the scope of that power in paragraph 1? I asked your colleague on the other side, what is your understanding of the scope of this legislative power of the governing authority of each county to adopt ordinances relating to its property affairs and local government? Does the property include just the property the county owns? Or is all of that sort of all the property in the county? How do you read that?
It's the county, it's the property within the jurisdictional limits of the county government.
Well, how is that not encompass zoning then? Because clearly zoning is something that affects the property within the county limits.
Because if it was the case that the home rule power conferred our zoning power on us, then the General Assembly would be able to substantively act in the area of zoning. Absolutely, because that's what that's the heart of the home rule power.
Well, that may be a consequence, but that doesn't mean that the interpretation is wrong, right? I mean, I agree with you. That would be the consequence of reading property to extend to sort of property within the county's territorial limits. I don't know how you read ordinances relating to property within its limits as not encompassing the zoning power.
Can I give you an example? Okay, so the types of manifestations of power that are reflected in the home rule clause are where the county government gets to act like a mini legislative body and is expressing powers that are not otherwise conferred. I don't use the word catch-all, but I want to go there, and then let me give you an example. Noise ordinances, pawn shop ordinances, massage spa ordinances, junk car ordinances, animal control ordinances, alcohol codes, the list goes on and on.
But counsel, what is the textual limitation that says those things are ordinances relating to property, but zoning ordinances aren't?
Well,
I don't see it in that
When you
provision.
talk about the property, though, think about what that is talking about. Counties don't have, as a general rule, they don't have extraterritorial power. Forsyth County can't zone or can't take action in Fulton, and we can't take action within the municipal limits of an incorporated city. So they're talking about property within its jurisdictional boundary for which we then have jurisdiction to adopt these legislative acts.
Right, and why, I mean, we've got a ton of case law saying zoning is legislative. Why?
It absolutely, forgive me.
What is the text that excludes zoning from that grant?
Because well, a couple of things. Number one, though, again, I have to go back to the expression of the power. The fact that the home rule power is subordinate to the General Assembly, the zoning power is not. How can those be the same two powers at the same time? One is uniquely limited by the General Assembly. One is uniquely not limited by the General Assembly.
But counsel, I mean, you say there's a conflict there, but doesn't paragraph 4 resolve that conflict? Because it then says that the General Assembly, with respect to zoning, can only enact general laws establishing procedures for that.
Correct.
So can we read both provisions, subparagraph A and paragraph 4 consistently and give effect to both?
Only if you decide under subparagraph A that the General Assembly has the right to make substantive zoning enactments.
Well, so, I mean, I see, I mean, I asked your colleague on the other side about this too. I see the tension there, right? You have paragraph A that expressly reserves to the General Assembly, I think, a sort of substantive power to expand or limit anything that comes under that. And then in paragraph 4, it reserves to the General Assembly the more limited power to enact procedural things. And so I see there's sort of a tension between, if zoning comes under A, what about 4? I think the way to resolve that, though, or one way to resolve that, is to say this is just a clarifying amendment or a clarifying provision, like your colleague on the other side said. It makes clear that you can also address procedures. What's wrong with that argument?
I would respectfully submit to you that that interpretation would be inconsistent, first of all, with the evolution of the case law governing zoning. I mean, the first manifestation of the home rule power, as this court is aware, was in 1966. It came along with the expression of the zoning power that for the first time took away zoning power from the General Assembly and gave it directly to the counties. And the first case out of the box in 1969 was Johnston versus Hicks, where in Johnston versus Hicks, this court made clear that the old rules were gone and the General Assembly had no quarter within the context of zoning, and in fact said that DeKalb County could in fact ignore, did not have to apply with the local act, comply with the local act. How can that be true? How could this court have said, General Assembly, you have no quarter anymore in zoning, if in fact zoning arises out of the home rule power?
In your understanding of our precedent is that we have precedent with respect to the current language of our current Constitution that says the General Assembly does not have the ability to substantively limit the zoning power.
I believe that is the law in the state of Georgia as it exists right now.
What are the best cases for that?
Well, Johnston versus Hicks is the one that I would indicate or would state is the most profound.
When was that decided?
1969. But it's
So that's
after the home
That's
rule.
two constitutions ago.
That's true, but it's after the 1966 Constitution where you see the home rule power that exists now and the zoning power. And the evolution of the placement of those two powers in the Constitution has borne out the sort of the powers that this court expressed. If there's one thing this court has made clear of over and over again, that the evolution of a power and how it waxes and wanes within the lineage of a Constitution matters. And so it matters now.
Let's look at the final sentence of subparagraph A under paragraph 1. General Assembly shall not pass any local law to repeal, modify, or supersede any action taken by any county government except as authorized by subparagraph C.
Right.
So the specter that the General Assembly can come in and rewrite local zoning law if zoning is a power under A doesn't really seem to track for me, because you can't do a local law under this power, under that last sentence. So you're saying that the General Assembly could not say every zoning scheme must provide at least X, value of multifamily residential. You're saying that power is gone?
That power is gone.
That can't be a statewide law?
It could not be a statewide law. In fact, and there are statutes quoted in our brief where literally the General Assembly will adopt a statute. Let's talk about agriculture. And they will say, nothing in this statute shall be construed as undermining the county's power of zoning. My point simply being, the General Assembly understands this limitation too. It's not accidental that the only substantive statute that the General Assembly has adopted is the zoning procedures law. To your point, Justice Bethel, I believe, and again I say only for myself, that if the General Assembly believed that they could act in the substantive realm of zoning, they would do it. But they do not do it, and the only area that they engage in is in procedure. And that sort of leads me to one other point as I attempt to distinguish the home rule power.
Can building codes be incorporated into zoning ordinances?
How about this? I've seen it done. So
when the legislature purports to regulate building codes, if a local government has assumed for itself under its zoning authority, in other words, it's claimed to itself, no, this is really zoning, then that generally applicable law would not apply under your theory.
I think that's where this court might say to the county, nice try, county, nice try to call building codes of zoning, but the reality is the authority for a county to adopt building codes is in Article 9, Section 2, Paragraph 3. That is an enumerated power on the Supplemental Powers Clause. Where you typically see that is in what's called development consolidated development codes as opposed to just a good old-fashioned zoning code that, uses true Euclidean zoning and divides up counties into certain areas. But yes, I've seen it done, and obviously there's some line blurring there. But if you were to ask me, where does that power come from for them to adopt it?
So is the ordinance in the record?
I don't think the ordinance, as far as the record in this case, is not in the record, no.
So
Does it
how
sort
do
of make
we,
it difficult for you to make the case? I mean, you're asking for action based on an ordinance that's not actually in the record, right?
The question, the ballot question itself identified it is the zoning enactment. I mean, that's literally the question that is being put to the voters.
So
Should-
what does the ordinance provide?
The issue was a differentiation with respect to the square footage of structures.
Is that the sort of thing that could have been in a building code?
It could not have been. That is a typical zoning-based performance standard.
Could it have been? I didn't ask, is it often in zoning? I just asked, could it have been in a building code?
I would take the position it could not have been.
but the reason why we're here is because of the ordinance, correct?
The reason we're here is because of the petition issued by Judge Webster to allow that referendum question to go to a ballot.
But
About the
bottom-
ordinance.
The
What's
bottom
that?
line is about the ordinance, correct? I mean, that's
The
the
ballot
issue.
question is about the ordinance, of
So
course.
if we don't have that in the record, what is the court to do?
Because the referendum question identifies both the fact that it is part of the hog hammock zoning
But what do we,
code.
but what do we review? I
You-
mean, don't we
you-
have to have the predicate?
You review the referendum question, you review the petition that was approved and the documents that were approved by Judge Webster, and that's all in the record.
Whose burden is it to put something like that in the appellate record?
It would be our burden.
Can I pivot for a second to the suit against Judge Webster, which is a suit against him in his official capacity? Typically, when county officials are sued in their official capacity, the county defends them and the county argues that sovereign immunity bars that lawsuit. Is there an exception to sovereign immunity for the claim against Judge Webster?
Well, in this case, sovereign immunity doesn't apply because it's two governments. And that's been well set forth by this court, that when two governments that both have immunity are battling out.
But is it
immunity
also
doesn't-
two branches?
I'm sorry, what?
Well, I mean, it's, usually when you talk about two governments, it's a county and a city. You have a right hand and a left hand and two different branches of government. So where does that leave us?
It leaves us with the idea that, first of all, the writ of prohibition, which is what we filed in addition to a declaratory judgment action, was against Judge Webster in his official capacity, which is what we understand is the law with respect to how you bring both a writ of mandamus and a writ of prohibition.
Mandamus petitions are brought in individual capacity.
I believe there's some law that suggests otherwise.
Well,
What's that?
that is often the case.
What's that now?
That is often the case.
Can I, before your time expires, can I ask a question about, again, this is a little bit because the ordinance isn't in the record. You raised the specter that if we go into a world in which the ordinance were repealed, then there would be this sort of Wild West because there would be no governing zoning at all.
Correct.
If I'm guessing right, because I don't have it in the record, you're referencing that there's some sort of repealer clause in the ordinance.
Not only is there a repealer clause, but there is ample case law, we quoted it, I believe, that suggests that when a new zoning code, any sort of a new ordinance is adopted, it supersedes its
Right,
predicate.
but if it has a superseding or a repeal or whatever you want to call it, if it's repealed by operation of an election, you go back to the previous state because the repealing didn't happen. I mean, you go back and say, we're removing all of this, right?
I don't think so, Justice Bessel. This ordinance, this zoning law has been in effect since September of 2023. It's been in effect, it's been implemented. So this idea that the referendum, because what that's
If a
talking.
statute is struck down, if this court or any other court strikes down a statute as unconstitutional, in other words, the General Assembly lacked the capacity to do the thing.
Okay, I'm listening. Yes, sir.
You don't go into a world in which there is no law. The law is what it was before the General Assembly acted.
Yeah, but that's different, Justice Bessel, because when it's unconstitutional, what the courts say is a void, an unconstitutional law is void. It never was law. That's not the case here. This was law. If this is going to be repealed, it's not going to be repealed because it's unconstitutional.
Essentially, your point about the referendum, the effect of a successful referendum of this sort is not that it renders the repealed ordinance void ab initio, it's that it simply represents a legislative repeal with an effective date of whenever the referendum happens.
That is absolutely the case, which if this...
Doesn't that, at least in part, though, require us to review the let's say that we were in a world where we were trying to assess how much of the injunction remains in effect. Doesn't that require us to review the ordinance and the text of the ordinance, at least to some extent?
Your Honor, I don't think it does, because the argument I was making there doesn't go to the heart of the issue as to whether the referendum clause can be used to repeal a zoning. I was simply attempting to point out for the court to understand a consequence of that, but it is not foundational as to how this court can rule. I mean, I think this court...
We've never passed on the question of how a repeal under the home rule provisions, how that's effectuated.
Not that I'm aware of, Justice Pastor, and that's fair. And I simply pointed it out as an anecdote in my briefing to let everybody understand that that is exactly what we believe the outcome will be if my honorable colleague's best case scenario is achieved. That was the only reason.
But counsel, hasn't the Superior Court somewhat fixed that issue, or at least made it less of a problem by implementing the injunction? So now the previous law is in effect currently, right, under the injunction. So if there's a repeal of this new provision, I mean, under the trial court's order, that old law still stays in effect. I mean, it's kind of an odd situation, but that's the state of it right now, is that the old law is currently in effect.
I'm going to pivot over now to where I'm the appellant. And so now I'm the appellant because now you're getting into my concerns about the injunction. So I hear you and I understand your point, but that is in fact one of my largest concerns with Judge McCorvey's injunction. So Judge McCorvey, and I'll get there, I promise, Your Honor. Judge McCorvey took a perfectly valid zoning code that had not been challenged from a constitutional standpoint. It was not asked to be declared ultra vires or void, and he terminated our ability to enforce it under the auspices of maintaining the status quo, and then he pivoted in the order and said, now you can take action for 1,400 square feet structures or less, but not 1,401 square feet structures or more. My position is that old code about 1,400 square feet, that's gone.
Well, counsel, I mean, it's not gone right now because of the injunction. And then turning back to the ordinance question, I mean, you're talking about specific provisions in the ordinance that we don't have in the record. So how is it that you will ever bear your burden of proving that the trial court abused its discretion in implementing the injunction without us being able to look at the ordinance to tell, I don't know how many square feet the houses are supposed to be under the old, under the new, and all that? I mean, how can you ever meet your burden without having the ordinance before us?
Two thoughts on that. Number one, with respect to the injunction, I'm the appellant, I lost. And the individuals that brought the actual request for the injunction that would have had the burden would be my colleagues opposite. With respect to the larger issue that's before...
But you have the burden on appeal. If you want to win your appeal, you have the burden of proving that the trial court abused its discretion in entering the injunction.
Well,
I don't think it's going to be a winning argument for you to say, well, the other side didn't bear their burden on their injunction below, so I win because it's not in the record. I mean, they've won. So now it's your duty as an appellant to show us why it's wrong.
The deficiencies in the record are one of the reasons this court should reverse. There was no evidence put into the record below. And Judge McCorvey acted with no factual evidence put into the record. So in that regard, I would agree with you, but I believe that's error on the trial court, not error in my raising that lack of evidence. with respect to that aspect of this appeal.
That's the party's duty, isn't it? To
Excuse
present
me?
evidence. Isn't it the party's duty to present evidence?
Well, it's the individual asking for the injunction. They have to show evidence of harm. It's the harm they're having to show as to why the status quo needs to be maintained, and my position is they did not show any harm, and therefore we should have that injunction overturned.
All right. Thank you, Mr. Gerard.
Thank you, Your Honor.
All right, Mr. Thompson, I believe you have 3 minutes left.
Thank you, Justice Peterson. Beginning very briefly with a concession, I concede that it is possible that property, as used in the home rule section, could refer to all property within the county's bounds. I don't have firm evidence to understand that as meaning only the county owned by the property. So I think it is possible that property also refers to all property within the bounds of the county, such that also could tie into zoning and the legislative grant of paragraph 1 also being what grants legislative authority for zoning procedures. I need to touch briefly, too, on a point opposing counsel began with about how it's Georgia's tradition that powers given to local governments are construed very strictly. That is true, and that is an important principle that guides both the standing argument in this case and the interpretation of the Constitution with respect to the referendum provision and the zoning power. The county has not pointed to and cannot point to any authority permitting it to interfere in this process. It's not in the Constitution. It was not in Camden. In fact, the county's interference in this process might even violate campaign finance laws because the county's not supposed to contribute anything of value either for or against a referendum. A question like this proposed to county voters.
Mr. Thompson, can you address the question about the ordinance not being in the record? Is that potentially a separate basis for dismissing the challenge because the county can't meet its burden to show that the ordinance does not fall under the subsection A powers that would be subject to the repeal?
I think it could be, Your Honor. None of the, as Justice Benson, as you're aware, traditionally the ordinances are supposed to be admitted into evidence before the trial court.
Is that something that we can take judicial notice of or not? Are you aware of authority?
I don't think so, Your Honor, because I think despite the fact that Georgia's adopted the new evidence code, it appears to have continued its tradition of requiring, our cases appear to have continued the tradition of requiring that ordinances, municipal ordinances, county ordinances be entered into evidence at the trial court. I think there's actually a separate provision of the evidence code that suggests they're still supposed to be separately admitted before the trial court. So I don't think they can be taken judicial notice of, which is a little bit different from the federal evidence code where I think they could be. Pivoting back to standing, really this is actually, because of my time, let me touch briefly on the interpretive question too. Accepting the county's position requires violating a number of interpretive principles. Expressio unius, canon of construction, because of the fact we have the legislative power explicitly granted in one section of the Constitution, why should we imply it in another grant? Justice Peterson, may I finish this one point?
You may finish your sentence.
Okay. Per your article, we're supposed to give meaning to changes in the constitutional order, and it's clear that the Constitution used to explicitly preempt zoning provisions from the referendum clause, but it does not any longer.
Thank you, Mr.
Justices,
Thompson.
for your time.
Thank you to counsel from both sides. Well and thoughtfully argued on both sides. We will get y'all a decision within the time required by the Georgia Constitution. And with that, we're going to take a 5-minute break and come back and hear the other two cases.
All rise. rise.